And today I will be performing the direct examination of Alex Fuentes and the cross-examination of Taylor Perkins.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Kasha Hires, and today I will be conducting the direct examination of Jordan Markowitz, the cross-examination of Avery Becker, and I will also be delivering the closing statement on behalf of the prosecution.
Good morning, Your Honor. Members of the jury, opposing counsel, my name is Miranda McCoy, and today I will be conducting the direct examination of Kyle Cusack, the cross-examination of Blake Van Owen, as well as delivering the opening statements on behalf of the prosecution. At this time, may our witnesses introduce themselves?
Please.
Good morning. My name is Matea Hires, and today I am Alex Fuentes.
Good morning. My name is Kai Salter, and today I am Detective Jordan Markowitz.
Good morning. My name is McKenna Selby, and today I am Kyle Cusack.
All right, then. Defense introductions.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Cindy Nguyen, and I will be performing the opening statement, the direct of Avery Becker, and the cross of Detective Markowitz.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Maggie Holland, and today I will be performing the direct examination of Taylor Perkins, the cross-examination of Alex Fuentes, as well as representing the Keystone attorney.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Raina Hilden, and today I will be providing the direct examination of Blake Van Owen, the cross-examination of Kyle Cusack, as well as the closing arguments. At this time, may our witnesses introduce themselves?
Please.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langen, and I am Avery Becker.
Good morning, Your Honor, opposing counsel and members of the jury. I'm Lucy Ingram, and this morning I will be Taylor Perkins.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Sarah Mazer, and I am Blake Van Owen.
All right. Next, do we have any pre-trial motions?
Yes, Your Honor, the prosecution does have a few pretrial matters. The prosecution requests that due to the virtual setting, lawyers may remain seated for direct examinations, cross-examinations, and objections.
Granted.
We also request that any remaining time for closing statements may be used for a rebuttal close.
Granted.
And then on sustained objections, would you like us to request that the testimony be stricken from the record, or should we assume that testimony has already been stricken?
I would say just assume it has been.
Thank you. We would also ask that timekeepers may use their discretion to stop time in the event of technical difficulties.
Yes, granted.
And then finally, we would like to establish the means for presenting evidence. We request that during the admission of evidence, the witnesses be allowed to look at the case materials that they have been provided with in front of them in order to identify exhibits for admission. And then once they have been identified and admitted, with the court's permission, co-counsel will then publish exhibits to the jury.
Granted.
Thank you. The prosecution has no further pre-trial motions.
All right, defense.
Yes, Your Honor. The defense asks that we would have permission for trial technicians to display exhibits on the screen for the purpose of entering them into evidence, or if they've already been entered into evidence for expediency's sake.
Granted.
Your Honor, as exhibits are initially displayed on the screen, the prosecution would ask that it be recognized that it is just to display the exhibit to the witness and opposing counsel, not to the jury until they have been published.
Granted.
And further, we would ask that exhibits, once they have been entered, would be constructively published to the jury, but they will just remain on screen.
Granted, yeah.
And we also ask for the trial technician to be able to annotate exhibits once they have been published to the jury.
Granted.
And lastly, in the event that someone is having technical difficulties, we ask permission for them to momentarily turn off their camera in order for the sound quality to improve.
Granted.
That is all for the defense, Your Honor.
All right. With that, then, I believe we can go ahead and begin opening statements. So, prosecution, you have the floor.
Yes, Your Honor, and for purposes of clarification, can you see and hear me all right?
Yes.
Thank you. May it please the court, counsel, members of the jury, we're here today because of tragic arrogance, which led to a tragic choice, which led to tragic consequences. The Colorado high school community mourned the loss of their mock trial coach, Mackenzie Brackman. But the defendant, Avery Becker, a former student and mock trial member at Colorado High School, is not grieving. Why not? Because Avery Becker killed Mackenzie Brackman, ending the feud that had been building between them since the day that they met. Now, how do we know that their relationship was strained? Well, let's look back at their time together on the mock trial team. Mock trial is an extracurricular in which students act as real lawyers and witnesses to put on a mock trial. Now, Avery constantly showed up late to mock trial practice. Avery was never prepared. Avery didn't listen to her coach's advice. We know that their relationship was strained because one day after mock trial practice, Avery decided to vandalize Mr. Brackman's car. As a result, she was kicked off the mock trial team. Now, this could have been the end of the story had Avery accepted the consequences of her actions. Instead, she made a plan to get back at Mr. Brackman. On March 6, 2020, she broke into Mr. Brackman's house with the intent of vandalizing it, as she'd done before to his car. However, Mr. Brackman was home during the time of the break-in. Alerted to the intruder by his Ring door app, he grabbed a knife in self-defense. Avery seized control of the knife, stabbed Mr. Brackman just below his shoulder blade, and ran out the front door, leaving him to die on the floor. Ladies and gentlemen, how do we know that Avery Becker was the one who broke into Mackenzie Brackman's house? How do we know that she planned to vandalize it? All we have to do is look at the evidence. Today, you will hear from Alex Cifuentes, a student at Colorado High School who was on the mock trial team with the defendant. Alex will testify that she received texts from the defendant indicating that she planned to break in and vandalize Mackenzie Brackman's house. What happens after Alex receives these texts? Surely enough, an intruder breaks into Mackenzie Brackman's house. Now, the defense may try and spin this story into one of ambiguity, but today you will also hear from expert witness Detective Jordan Markowitz, one of the first people to arrive at the scene. When he arrives at the home, what does he find? The dead body of Mackenzie Brackman sprawled on the floor with a stab wound in his shoulder and a bloody knife lying beside him. Detective Markowitz begins to look for suspects, and when he learns of the texts that the defendant sent to Alex Cifuentes, well, he follows that lead. But what happens when Detective Markowitz gets a search warrant for Avery Becker's phone? Well, Avery claims to have lost her phone the day before the murder. But Detective Markowitz doesn't let this deter him. Today, you will hear him explain to you what he discovered in his investigation, including cell phone tower records that show that the defendant was traveling to Mackenzie Brackman's home just before the murder. Now, the defense is here to say that Avery Becker did not commit these crimes, but you will also hear from expert witness Kyle Cusack, a certified crime scene reconstruction investigator, who will tell you that this was simply not the case. She reconstructed this crime, and the evidence at the scene pointed her to the conclusion that this murder was not premeditated. After reviewing the evidence, she concluded that this was clearly a planned burglary gone wrong. After reviewing the evidence, she concluded that the murder weapon was taken from within Mackenzie Brackman's own house. Ladies and gentlemen, we acknowledge that as the prosecution, we bear the burden of proving the defendant's guilt beyond a reasonable doubt. And today, we will do just that. At the close of this trial, once you have heard all the evidence, we will ask you to find the defendant guilty of all charges, because tragic arrogance led her to make a tragic choice, murdering an innocent man. And tragically, that choice must have a consequence: the conviction of Avery Becker for the murder of Mackenzie Brackman. Thank you.
All right. Defense, your opening.
Yes, Your Honor. May it please the court, Your Honor, members of the jury, opposing counsel. Good morning, my name is Cindy Nguyen, and along with my co-counsel, Raina Hilden and Maggie Holland, we are honored to be representing the defendant, Avery Becker. On March 6, 2020, the Colorado High School mock trial team's coach, Mackenzie Brackman, was murdered in his own home. My client, Avery Becker, stands here today accused of this crime. But the truth of the matter is that she did not do it. The prosecution jumped to conclusions and fell short in investigating the killer of Mackenzie Brackman. Now, the law provides that all defendants are innocent until proven guilty. The burden of proof is borne by the prosecution, and they must prove my client's guilt beyond a reasonable doubt, which they will fail to do because of their flawed investigation. You're going to see screenshots of text messages between Avery Becker and Alex Cifuentes. However, beware of Cifuentes' bias against my client. She was another member on the mock trial team who is not happy with Avery Becker's accomplishments. And today, she stands on the side of the prosecution, claiming that my client sent these messages. Furthermore, you will hear that the prosecution jumped to conclusions and fell short by failing to authenticate these messages. You're going to see pictures of cell tower diagrams tracking my client's phone on the day of the murder. However, that cellular device does not represent the whereabouts of Avery Becker, as she did lose her phone the day before. And furthermore, these cell towers will prove to be unreliable as they can reach up to 6 miles away. You're going to see videos of a masked intruder unlawfully entering Mackenzie Brackman's home. Now, the prosecution will claim that my client has the same build as this intruder. However, the prosecution jumped to conclusions and fell short by failing to investigate another person with the same build and body type as this intruder, someone with a greater motive to kill Mackenzie Brackman, and that person is Blair Rollins. You see, a few months before the murder, Mackenzie Brackman failed to protect his client, Jonathan Rollins, against a murder charge, and Rollins was convicted and sentenced to life in prison. From his imprisonment, Rollins' child lost a father. Now, this child, Blair Rollins, could be an equal suspect in this case, but once again, the prosecution jumped to conclusions and fell short by failing to investigate any suspects other than my client. Listen to the prosecution explain how they investigated the whereabouts of Blair Rollins on March 6, 2020. Without the evidence, members of the jury, you have the basis for reasonable doubt. The defense will call 3 witnesses, Avery Becker, Taylor Perkins, and Blake Van Owen. The defendant, Avery Becker, was a naturally gifted, award-winning attorney on mock trial. You will hear that Ms. Becker and Mr. Brackman did not have a great relationship. However, despite these conflicts, you'll hear that Ms. Becker attempted to make amends with Mr. Brackman up to the day of his death. While the two did not always see each other eye to eye, they were on the same team, the mock trial team. Our second witness, Taylor Perkins, will testify that Avery Becker was with her the entire day of March 6th. The two spent the entire day retracing their steps at the mall and the fry shack, searching for the missing phone. Taylor Perkins will testify under oath that Avery Becker has an ironclad alibi for the date and the time of the crime. Our third witness, Blake Van Owen, will dispute the prosecution's claims of how the murder was carried out, and she will question the validity of every piece of evidence that the prosecution collected during their investigation. Not only was their investigation sloppy, but they managed to lose pieces of evidence as well. Like I said, the prosecution is not interested in the truth. They're simply jumping to conclusions to get a quick conviction. At the end of this trial, my co-counsel, Raina Hilden, will recount the instances in which the prosecution jumped to conclusions and fell short in procuring the evidence presented to you today. Like I said, in order for my client to be deemed guilty, the prosecution must meet the burden of proof, which is to prove Avery Becker's guilt beyond a reasonable doubt, which they will fail to do. At the end of this trial, we ask that you rule in favor of the defense and acquit Avery Becker of her own coach's murder. The evidence will show that Avery Becker is innocent. Thank you.
All right, then, with that, we will go ahead and move to the prosecution's case in chief. So, prosecution, would you like to call your first witness?
Yes, Your Honor. The prosecution calls Miss Alex Cifuentes to the stand. Ms. Cifuentes. There you go. May I proceed, Your Honor?
Yes, please do.
Good morning, Ms. Cifuentes. Could you please state your name and spell it for the court?
Yes, my name is Alex Fuentes, and my last name is spelled Sifuentes.
I want to begin by talking about the mock trial team you were part of, and the relationship between the defendant in this case, Avery Becker, and the coach of that team, Mackenzie Brackman. What was your relationship like with the defendant, Avery Becker?
Avery and I have always been pretty good friends. She actually convinced me to join the mock trial team when I was a freshman.
So, given your personal experience, how was Mr. Brackman and Avery's relationship on the team?
Avery always played the victim and didn't really work hard, and I think that they were both pretty frustrated with each other.
And what was the result of that mutual frustration?
Well, Mr. Brackman was always telling Avery to do a better job of preparing for practice and tournaments, but Avery simply refused, and I think the tension between them just got out of hand.
Was there a specific moment you felt embodied that?
I think that it reached a boiling point after Avery came late to practice for the millionth time. And after that practice, Mr. Brackman demoted Avery to the B team.
I want to talk about the events that led to Avery being removed from the mock trial team. What did Avery do after being demoted?
Well, she somehow convinced Taylor Perkins, who's Avery's second best friend,
Your
to...
Honor, speculation.
All right, counsel, your response. Well, can you clarify what the speculation is first?
Speculation goes to what Ms. Cifuentes thinks happens, and she was not there at this to witness this interaction.
All right, and counsel, your response.
Your Honor, the witness is simply testifying as to their knowledge of events that occurred based on their conversations with the defendant and conversations with other members of the mock trial team. They're not directly testifying to their experiences of this event, but rather their experiences of what they were told about this event.
Hey, and can you repeat the statement at issue one more time?
Myself.
Would you like me to repeat what I said?
Yes, please.
I said they somehow convinced Taylor Perkins, who was Avery's second best friend, to quit the team, and Brackman had to let Avery back on the E team after that.
Yeah, I'm going to sustain that objection.
I'll move on. What happened concerning the mock trial team after Avery got back on?
Well, we went to regionals and Avery won Best Attorney and Best Closing Award.
And how did Mr. Brackman react to that?
Mr. Brackman tried to explain to Avery that even though she won those awards, Avery shouldn't confuse good showmanship with good lawyering. He told Avery that what she did would be considered malpractice in the real world.
And what did Avery do after Mr. Brackman tried to talk to her?
Well, Avery got super mad and she vandalized Mr. Brackman's beautiful vintage 1986 Porsche 911 with a permanent marker, writing Worst Attorney Award on the hood. And after that, Mr. Brackman removed Avery off the team for good.
Now, I want to turn to how Avery Becker responded to being fully removed from the team. What, if any, contact did you have with Avery after Mr. Brackman removed her?
Avery texted me and asked for help getting back on the team.
And how did you respond to that request?
I did think that the team was a little bit better off without Avery, but I agreed to try and convince Mr. Brackman to let Avery back on the team on Avery's behalf. But he was just not interested. It was more than just the Porsche incident and been everything that had been going on for the past 4 years.
I'd like to discuss your experiences regarding the investigation of this murder. Who, if anyone, contacted you regarding the murder?
I talked to Detective Markowitz at the Denver Police Department about the text messages that I exchanged with Avery, and he wanted a whole interview.
What text messages are you specifically referring to?
Avery texted me asking for help getting back on the team.
This text conversation has been marked as Exhibit 14. Do you have a copy of Exhibit 14 in front of you?
I do.
And do you recognize this?
Yes.
What is it?
These are the text messages that I exchanged with Avery.
And is it a fair and accurate representation of those texts?
Yes.
Your Honor, at this time, I move to admit Exhibit 14 as evidence.
Any response from the defense?
Yes, Your Honor, I have 3 objections. Under Rule 801, hearsay because this is an out-of-court statement made by a party opponent. Under Rule 901, the authenticating evidence, the proponent has failed to produce sufficient evidence aside from the claims of Ms. Cifuentes that this is Avery Becker sending these messages. And under Rule 1002, requirement of the original, this is a screenshot of the text messages and therefore is not the original.
Your response, counsel.
Your Honor, would you like me to respond to all of the objections at once or one at a time?
One at a time, please.
I'll start with the hearsay objection. In this case, the text messages from Avery Becker are a statement by a party opponent under Rule 801D2A. And as for the statements by Alex Fuentes, they're not being offered to prove the truth of the matter asserted, but rather they are being offered to establish context for the statements by Ms. Becker.
All right.
Your Honor, I believe she's not responded to under Rule 1002 requirement of the original.
Yes. Would you respond to that as well, please?
Yes, Your Honor. Under Rule 1001D, for electronically stored information, original means any printout or other output readable by sight if it accurately reflects the information. By rule, these screenshots are not considered copies, but rather under the rules, originals, and thus Rule 1002 does not apply.
All right. I am going to allow this in.
Permission to publish to the jury, Your Honor?
Granted.
My co-counsel should be sharing that exhibit shortly. Now, Ms. Fuentes, are these the original text messages directly printed from your phone?
No, this is actually a printout of the screenshots that I emailed to the detective.
And why didn't you provide the detective with the originals?
Well, when my dad yelled that it was time to go for the interview, I completely forgot that my phone was charging and I accidentally left it at home.
And what happened once the detective realized that you did not have the original texts?
We offered to come back with the phone after the interview, but the detective told us that it was okay and he just asked me to send screenshots of the text instead.
Will you please read the final 2 texts from Avery Becker?
Yes, it says, I'm going to wait until he's at work, then break in and trash it. That'll show him.
What was your reaction to those texts?
I was worried. I mean, based on those texts, I thought that Avery planned to go to Mr. Brackman's house while Mr. Brackman's at work and trash the place, just like she did with his car.
I want to address some issues now about the defense's investigation into this case. Did you speak to anyone investigating the case other than Detective Markowitz?
Yeah, I talked to a PI for the defense. I told the investigator that I had no interest in talking to her, but she persisted in asking me a few questions.
Can you describe what happened during that conversation?
I learned that I was basically being accused of faking the text messages from Avery. I would never even consider creating a fake text exchange.
Was there anything else the defense informed you of?
They also accused me of stealing Avery's phone and giving it to some kid named Blair Rollins, who I learned may have been involved in this case.
Did you know Blair Rollins at all?
I knew him, but I didn't have any meaningful relationship with him. We barely knew each other well enough to say hello and goodbye when we passed across in the hall.
How would you like to respond to the accusation of stealing Avery's phone?
I certainly would not have stolen Avery's phone for Blair Rollins.
I'd now like to further address your friendship with Avery Becker. Did you consider you and Avery to be rivals at all?
No, I wholeheartedly disagree with that. Avery and I weren't rivals in mock trial. We were teammates and we were friends. And Avery and I liked each other very much, which is why Avery actually texted me for help getting back on the team.
And lastly, how has this tragedy affected your perspective of this case?
Mr. Brackman was a great coach, and this whole experience for me has been devastating. I never really thought before about things happening and trials affect people, but this is real. Coach Brackman is dead.
Thank you. Your Honor, at this time, I have no further questions.
All right, then, defense cross-examination.
Yes, Your Honor. Good morning, Ms. Cifuentes. Let's start by talking about Ms. Becker. You know Avery Becker from your high school mock trial team, yes?
Yes, but we were also friends outside of school too.
And you were teammates for 3 years?
Yeah, she was actually the one that convinced me to join the mock trial team when I was a freshman and she was a sophomore.
You were a hardworking member in mock trial, correct?
Yeah, I considered myself to work really hard and do all the work that I needed to get done.
And you took it very seriously, yes?
Yes.
You don't think Avery worked very hard in mock trial, do you?
She was good, but she never really prepared for anything, and I think it just threw the whole team off.
And despite being rarely prepared, in your opinion, she frequently received awards, didn't she?
Yeah, like I said, she was good, but she just never prepared, and I think it just threw the whole team off.
But these frequent awards that she received, that bothered you, didn't it?
Yeah, a little bit. I mean, like I said, she never prepared for anything, and it was really frustrating to see somebody else win awards when they didn't prepare.
And Avery was kicked off of the team by Mr. Brackman, correct?
Yes, I believe so.
It opened up an opportunity for you to get a larger role on the team, didn't it?
Yeah, I guess.
And you were glad Avery was kicked off of the team, weren't you?
In some ways, yes.
Avery texted you asking to speak to the coach on her behalf, is that correct?
Yes.
But you do not have these texts, right?
I have the screenshot of them.
But you have fallen short in producing your phone with the original texts, have you?
The battery was starting to go bad, so I traded it in. But the detective told us that it was fine, and he just asked me to send screenshots of the text.
And you said that you had traded this phone in a few months ago?
Yes.
Knowing that your former classmate was facing trial for first-degree murder?
Yes, because I thought the screenshots would suffice.
But you also knew that your phone was containing this evidence, and you still traded it in, yes?
Yes, because the detective told us that the screenshots would suffice.
And speaking of phones, Avery let you play a game on her phone at the Fry Shack the night before the murder, yes?
Yes, we were good friends, and she let me play on her phone sometimes.
So you had the phone the night before the murder, yes?
Yes.
And you and Avery texted back and forth in the past, correct?
Yes.
If you will turn your attention to Exhibit 14, I believe my trial technician will screen share it momentarily. Thank you. As you see on these text messages with the threats of breaking in to Mr. Brackman's house, you had previously said that you were worried about Mr. Brackman and his estate, but you didn't warn him after receiving these texts?
No, I did not.
And you didn't call the police the day before?
No, I did not.
If I can turn your attention to the first text written by Avery Becker saying, "Hey, Alex, it's Avery." Avery was a saved contact in this phone, correct?
And that is correct.
So her name would appear on your phone whenever she texted, yes?
Yes.
Every single time it would have given her name. So she wouldn't have needed to identify herself, would she?
Well, sometimes I do identify myself just to make sure that they actually do have my cell phone number in their phone. Sometimes contacts accidentally get deleted. So it makes sense, actually.
Ms. Cifuentes, I was just asking if it was necessary and not whether or not you would have done this, but if Avery would have done this.
Avery did it.
Yes, but it was not necessary, correct?
I think that, I guess it's not necessary, but I do it and she did it, so I don't.
Thank you, Your Honor. No further questions.
All right. Prosecution, would you like to redirect?
No redirect, Your Honor.
All right, then. Ms. Fuentes, you may take a seat. And prosecution, would you like to call your next witness?
The prosecution calls Detective Jordan Markowitz to the stand. May I proceed, Your Honor?
Yes.
Good morning. Please state your name and spell it for the court.
Jordan Markowitz, JordanMarkowitz.
Thank you. I'd like to begin with your background and experience in homicide investigation. What is your profession?
I work as a homicide detective with the Denver Police Department.
And do you have any specialized training?
Yes, I have specialized training and experience in cell phone technology and forensic data recovery.
And how long have you done this?
I've been with DPD for 13 years and I've been a detective for 7.
I'd like to turn back to your specialized training that you mentioned. Can you please elaborate on that?
Yes, I received a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. To get this certification, I had to complete a 3-day training course and pass a certification exam.
And what did you learn in this course?
In this course, I learned about the different types of cell detail records, how to obtain and interpret cell tower data, and how to obtain and interpret cell phone technology and forensic data.
And in how many cases have you used this certification?
I've used this certification in over 50 cases on over 100 cell phones.
And what is your relation to the case today?
In March of 2020, I was assigned to investigate the death of Mackenzie Brackman.
Your Honor, I'd like to move to admit Detective Markowitz as an expert in homicide investigation, as well as cell phone technology and forensic data recovery.
All right, defense, you have any response to this?
Your Honor, I have no objections to Detective Markowitz being admitted as an expert in criminal investigation. However, I object to the specialization in cell phone technology and forensic data recovery, as I believe that only 3 days of training is not sufficient to prove that Detective Markowitz is specialized in 2 separate fields.
Your Honor, may I respond?
Yes.
Under Rule 702, a witness can be qualified on the basis of knowledge, skill, experience, training, or education. And the 3-day training course is not the only training that Detective Markowitz has received. He has used this certification in over 50 cases on over 100 phones, which is enough experience under Rule 702 to be qualified as an expert.
I would just ask that you lay a bit more foundation before I go ahead and admit him.
Yes. Detective Markowitz, how often do you use this certification?
I use this certification quite often. In many cases, it's necessary to use the cell phone technology and forensic data recovery certification.
And can you clarify again just how many times you have used this certification?
I have used it in over 50 cases on over 100 cell phones.
And what exactly do you believe is your area of expertise?
I believe I have an expertise in cell phone technology and forensic data recovery.
Your Honor, I once again move to admit Detective Markowitz as an expert in cell phone technology and forensic data recovery. As he has stated, he has sufficient experience and training under Rule 702 to qualify him as an expert in this area.
All right, at this time, I am going to go ahead and admit him in which were the areas that you requested?
Homicide investigation was the first one that the defense had no objection to, and the other 2 were cell phone technology and forensic data recovery.
He is so admitted in all 3 areas.
Thank you. May I proceed?
Yes.
I want to turn to the movements of Avery Becker on the day of the murder. What steps did you take to track Avery Becker's whereabouts on March 6th?
I obtained a search warrant for Becker's phone, which I was unable to search, and I obtained a court order to obtain cell detail records for Becker's phone on March 6th.
Why were you unable to search Becker's phone directly?
When I contacted Becker's lawyer, she claimed that Becker had lost the phone on March 5th.
You mentioned that you obtained cell detail records from Becker's phone. Could you please provide a little background on how those work?
Yes, so even when a cell phone's not in use, it's constantly reaching out to find a cell tower to connect to. Now, the service provider doesn't record all of this, but it does record a few important moments, like when a text is made or a call is placed. And the most important detail that's recorded by the service provider is the cell tower with which the cell phone is communicating.
And how do cell phones determine which cell tower they connect with?
There's a complex algorithm to determine which cell tower is best, but the best tower is almost always the closest tower.
Are there ever instances when the cell phone does not connect to the closest tower?
Yes, for example, if an area was very busy, however, the closest tower is almost always going to be the tower that's connected to the cell phone.
And what did the cell detail records from March 6th obtain from Ms. Becker's phone show?
Another phone, which I later found out belonged to Taylor Perkins, was placing in many texts and calls to Becker's phone.
And were these calls and texts ever answered?
No, they were not.
What else did you observe about the call detail records from that day?
All activity from the phone ended on March 6th, meaning the phone was either turned off or destroyed.
Thank you. I'd like to turn your attention to what has been previously marked as Exhibit 16. Do you have this exhibit in front of you?
Yes, I do.
Do you recognize this exhibit?
Yes, this is a diagram I made that summarizes the cell detail records I obtained for Avery Becker's phone.
And is this a fair and accurate representation of the diagram you made?
Yes, it is.
Your Honor, I'd like to move to admit Exhibit 16 into evidence.
All right, defense, any response?
Your Honor, I have two objections. My first is under 801, this is hearsay, and my second is that this exhibit should be excluded under Rule 403 for misleading the jury. The evidence only shows that the phone is in the vicinity of the cell towers. However, these cell towers can reach up to 6 miles away.
All right, prosecution, your response to that.
Under Rule 803.6, this is not hearsay, as it is a record of a regularly conducted activity as a part of Detective Jordan Markowitz's investigation. And as for the second objection, the Detective Markowitz has been admitted as an expert in cell phone technology and forensic data recovery. So he can, through these records, triangulate the approximate area where a phone would be, as that pertains to his expertise.
All right, could I see a copy of the evidence?
Yes, my co-counsel may screen share that now constructively.
Okay, yeah, I'm gonna allow this one.
Thank you. May this exhibit now be constructively shared to the jury?
Yes.
Detective Markowitz, can you please explain what is shown by this diagram?
Yes, so at 12:47, Becker's received a text from Perkins, and the communication was consistent with the cell tower that covers Becker's house. Then at 12:55, Becker's received another text, and this time the communication went through the cell tower that covers Rock Creek Parkway. These text messages show the movement of the phone, and the blue line shows the route that Becker's phone took to get to Brackman's house on March 6th.
Thank you. Now, before we heard testimony from Alex Fuentes about a text conversation with Avery Becker, I'd like to turn your attention to what has been previously admitted as Exhibit 14. How did you obtain these text messages?
I spoke with a student by the name of Alex Cifuentes, who said that another student named Avery Becker had texted her about plans to break into Mackenzie Brackman's house and trash it.
And who was this other student?
Avery Becker.
And what exactly were the contents of these text messages?
Becker texted Cifuentes and said, "I'm going to wait until he's at work, then break in and trash it. That'll show him," referring to Mackenzie Brackman's house.
And why were you unable to retrieve these texts during your initial interview?
During the initial interview, Ms. Cifuentes had forgotten to bring her phone, so I asked her to send screenshots the following day.
And is Exhibit 14 an accurate copy of those screenshots?
Yes, it is.
Thank you. I'd like to move on to talk about what you found at the scene of the crime. Did you observe anything outside the house when you first arrived at the scene of the crime?
Outside the house, I noticed that the home is equipped with Ring security cameras. I also noticed that the back gate was unlatched and the back door was open.
And did you receive these Ring records as a part of your investigation?
Yes, during my investigation, I was able to obtain account information and passwords for Brackman's Ring, and I was able to download all the videos that the cameras captured on March 6th.
I'd like to turn your attention to what has been previously marked as Exhibit 12. Do you have this in front of you?
Yes.
Do you recognize this exhibit?
Yes, this is one of the videos that was captured by Brackman's Ring on March 6th.
And is this a fair and accurate representation of the video you recovered from Brackman's Ring?
Yes, it is.
Your Honor, I'd like to move to admit Exhibit 12 into evidence.
Defense, any response?
No objections, Your Honor.
All right, then it is so moved.
May my co-counsel publish to the jury.
Please.
Detective Markowitz, can you please explain what is shown in this video?
This video shows an intruder wearing gloves, a hoodie, and a mask breaking into Mackenzie Brackman's residence. Additionally, the height and build of this intruder matches that of the defendant today, Avery Becker.
And what does this show about what happened on March 6th, 2020?
This shows that Mackenzie Brackman had interrupted a break-in before his murder.
And in your expert opinion, based on past homicides you have investigated, what do you believe happened on March 6th?
In my expert opinion, it is fairly obvious that Mackenzie Brackman found an intruder breaking into his house, grabbed a large knife to defend himself, and began struggling with the intruder. Then, during the course of the struggle, the intruder gained control of the knife, stabbed Mackenzie Brackman. He then ran to the front door where he collapsed, either running away from or after the intruder.
And in your expert opinion, based on all of the evidence you reviewed, who traveled to Mackenzie Brackman's house on March 6th, 2020?
In my expert opinion, based on cell detail record evidence, text message evidence, interviews with relevant witnesses, and ring video evidence, it is absolutely clear that Avery Becker traveled to Mackenzie Brackman's house with the intent to break in and vandalize it,
Your Honor.
found him home, and killed him.
Objection, Your Honor.
Sorry.
Your Honor, you're muted.
Let's hear the objection.
Under Rule 704B, the opinion on an ultimate issue, in a criminal case, an expert witness must not state an opinion about the defendant or the mental state of whether the defendant did or did not have that constitutes an element of the crime charged.
Your Honor, may I respond?
Yes.
This witness is admitted as an expert in police investigation, and so he is not testifying to Avery Becker's state of mind during the crime. He is simply reviewing all the evidence and stating his conclusion based on that evidence. So this rule is not applicable in this case.
Response, Your Honor.
Briefly.
I believe that Detective Markowitz stated that Avery Becker had the intent to commit the crime, and that is testifying to the mental state, which is a fact for the jury to determine.
Yeah, I am going to go ahead and sustain the objection and just request that you can go ahead and opine as to what you believe happened. Just try and restrict yourself from opining on the mental state.
Okay. Would you like me to ask that question one more time, Detective Markowitz, or can you?
Yes, thank you.
So in your expert opinion, based on all the evidence you reviewed, who traveled to Mackenzie Brackman's house on March 6th?
Based on my expert opinion and all the evidence I reviewed, Avery Becker traveled to Mackenzie Brackman's house on March 6th.
Thank you, Your Honor. I have no further questions at this time.
All right, defense cross-examination.
Yes, Your Honor.
May proceed.
Detective Markowitz, you reached several conclusions for today's trial, and I wanted to talk to you about the evidence you collected to come to these conclusions. Let's start with the evidence at the crime scene. Pictures were taken of blood spatter found inside Mackenzie Brackman's home.
Yes, the forensics team took many pictures of the crime scene.
But the digital files in the camera became corrupted and could no longer be recovered.
Yes, the photos of the blood splatter were corrupted.
Now, I would like to direct your attention to the ring videos you referred to earlier. Let the record reflect that the trial technician is screen sharing what has previously been marked as Exhibit 10. And Exhibit 10 is another ring video captured by Brackman's ring on March 6th, except from the front door.
Yes, that is correct.
And this video is a fair and accurate representation of the video recovered from Brackman's ring.
It is.
Your Honor, at this time, I move for the admission of Exhibit 10 into evidence.
All right, prosecution, any response?
I have no objection to the admission of this exhibit, Your Honor.
All right, then it is so moved.
Let the record reflect that the trial technician will start playing the video and stop at 4 seconds.
So Detective Markowitz, you claim that this is Avery Becker.
I do.
And if you can look at this video and the person in it right here, you don't know the race of the person in this video.
No, they're showing no identifiable features other than height and build.
You don't know their age.
I do not.
You don't know their gender.
I do not.
So you jump to the conclusion that this is Avery Becker, even though you don't have any concrete evidence of their characteristics.
It was not the ring videos alone that led me to the conclusion that this was Avery Becker, but rather the total of all the other evidence in the case as well as the ring videos.
However, if you can answer my question, you cannot conclude that this is Avery Becker in this video.
I can conclude it is Avery Becker based on other evidence, but not based solely on the video.
Now, Detective Markowitz, Brackman was a criminal defense lawyer, correct?
That's right.
And this intruder could also be a disgruntled ex-client of Mr. Brackman's, as you proposed earlier.
Yes, that is correct.
And Jonathan Rawlings was an ex-client of Mackenzie Brackman's.
Yep.
Now, moving on to another piece of evidence you collected, the cell tower diagrams. Let me direct your attention to Exhibit 16, and the trial technician will display this exhibit. Detective Markowitz, can you see the mall on the picture?
Yes, I can.
And phones connect to towers with the strongest connection, correct?
That's right.
However, a phone can connect to a tower further away in busy areas, such as an area around a mall.
Perhaps. However, I doubt a mall would be busy enough for that to happen, but it is possible.
This was a Friday afternoon when schools are let out, correct?
I believe the time of the cell detail records was during school hours, but it was Friday.
Now, call detail records cannot pinpoint the exact location of a phone, like GPS.
No.
And there's no way to determine who is in possession of the phone.
Not from the cell detail records alone, no.
Now, directing your attention to one of your witnesses, your biggest lead came from Alex Cifuentes.
Yes.
And this lead was evidence of text messages between Cifuentes and who she claims is Avery Becker.
That's right. I did receive screenshots of text messages from Ms. Cifuentes.
Let the record reflect that the trial technician is screen sharing what has previously been marked as Exhibit 14. Detective Markowitz, you didn't take this evidence directly from Cifuentes' phone.
No, I did not. I received screenshots of the evidence.
And that's because Cifuentes didn't bring her phone to the meeting.
Yes, that's right.
However, you didn't try to reschedule another day to obtain the device?
No, I preserved the evidence by obtaining the screenshots.
And you asked for screenshots instead?
Yes.
And you didn't receive them until an entire day had passed?
Yes, I received the screenshots the following day.
So you never saw the phone with the actual messages on it?
No, I did not.
You didn't see what messages preceded or proceeded the ones shown in this screenshot?
No.
And there are no time or date stamps shown on these screenshots of when the messages were exchanged?
No, there are not.
The screenshots don't explicitly show a number that is or is not Avery Becker's?
No, they don't.
And you acknowledge that there are ways to forge a text conversation, like through a text messaging app?
Yes, it is possible to forge a text conversation.
And it is also relatively easy to change the name of a contact, correct?
It is easy to change a contact name.
And just to clarify for the jury, you accepted these screenshots without validating that the number is or is not Avery Becker's?
Yes, that's right.
Thank you, Your Honor. No further questions.
All right, prosecution, would you like to redirect?
Very briefly, Your Honor. Detective Markowitz, why didn't you pursue other suspects in this case?
When I'm investigating a case, I go where the evidence takes me, not where I want the case to go. And in this case, all the evidence pointed to Avery Becker.
Thank you, Your Honor. I have no further questions.
All right. At this time, would the prosecution like to call their next witness?
Yes, Your Honor. The prosecution would like to call Ms. Cal Cusack to the stand.
Right.
Before I begin, could I get a brief time check?
Yes, you have 9 minutes and 41 seconds remaining.
Thank you. Good morning, Ms. Cusack. If you could please state your name and spell it for the record.
Kyle Cusack, K-U-Z-A-K.
Thank you. I'd like to begin by talking about what you do for a living. What do you do for work?
I am a crime scene reconstruction investigator, also known as a CSR.
Have you achieved any certifications in this field?
Yes, I am certified by the Colorado Bureau of Investigation in crime scene reconstruction and investigation.
Where do you work?
I worked as a civilian employee of the Denver Police Department.
How long have you worked there?
I've spent the last 3 years of my tenure there.
What have you been doing while you were there?
I have 19 years of experience investigating complex crime scenes, which is my role at the DPD.
What kinds of complex crime scenes?
Home invasions, burglaries, homicides, fatal accidents, domestic violence, and armed robberies.
And when you investigate these complex crime scenes, what principles guide your investigative process?
First, I assume that every case is going to trial, so I conduct a thorough, comprehensive investigation accordingly. And second, I memorialize, document, and organize all evidence with a mindset of future reconstruction.
And what is your relation to this case?
I visited the scene of the homicide and reconstructed the crime. I also reviewed all of the police reports, photographs from the scene, and the 4 Ring security camera videos.
Your Honor, at this time I move to admit Ms. Kyle Cusack as an expert in crime scene reconstruction and investigation.
All right, defense, any response?
No objections or voir dire at this time, Your Honor.
All right, then she is so admitted.
Ms. Cusack, I'd like to talk to you about your CSR process. How do you approach your CSR work?
I approach it in 5 parts. First is recognition and documentation, then collection of evidence, evaluation of evidence, hypothesis and testing, and finally, reconstruction.
How did you approach your 5-step, or how did you apply your 5-step process in this case?
I use a witness tracking spreadsheet to summarize information from witnesses and suspects. I also use a physical evidence tracking sheet to document observations about the evidence.
Now let's talk about the crime scene. What evidence did you find there of a struggle?
When I visited the scene, I observed scuff marks on the floor along with a broken plate.
Where did you observe the scuff marks?
On the kitchen floor near the back door.
And where did the intruder break into Mr. Brackman's house from?
Through the back door, which is where I noticed those marks.
And where did you notice the broken plate?
About 5 feet from the back door.
I'd like to direct your attention to what has been previously marked as Exhibits 9 and 18. Do you have a copy of those in front of you?
Yes, I do.
What are they?
Exhibit 9 is a photograph of the broken plate I observed at the scene, and Exhibit 18 is a photograph of the scuff marks I observed on the victim's kitchen floor.
And are these exhibits a fair and accurate representation of the scuff marks and broken plate?
Yes, they are.
Your Honor, at this time I move to admit Exhibits 9 and 18 into evidence.
Defense, any response?
No objections, Your Honor.
All right, then they are so moved.
Your Honor, permission from my co-counsel to publish those exhibits to the jury?
Please.
Ms. Cusack, what do the scuff marks and broken plate suggest happened?
These indicate that there was a struggle of 2 individuals engaged in close contact near the kitchen by the back door. That struggle then moved from the back door to the kitchen table, where the plate was likely knocked to the ground as the individuals were struggling.
And then what other evidence did you notice in the kitchen?
I also observed an open knife drawer with many different types of knives inside of it, along with a knife block that was missing a large chef's knife, the same type of knife we recovered from the victim's body. All of this led me to conclude that the murder weapon was taken from within the victim's home, pointing away from this being a premeditated murder.
And talking more about the murder weapon, where was it recovered?
Just inside the front door.
And what is that position consistent with?
This is consistent with the victim having been stabbed near the kitchen, then proceeding to the front door and removing the knife there.
I'd now like to turn your attention to what has been previously marked as Exhibit 3. Do you have a copy of Exhibit 3 in front of you?
Yes, I do.
What is it?
This is a photograph of the stab wound that killed Mackenzie Brackman.
And is it a fair and accurate representation of the stab wound?
Yes, it is.
Your Honor, at this time I move to admit Exhibit 3 into evidence.
Defense, any response?
Yes, Your Honor. I do object on the grounds that the jury has not heard enough foundation yet as to Ms. Kuzak's personal knowledge of the authenticity of this knife wound.
All right, I will request that you lay some more foundation for it.
Ms. Cusack, did you visit the scene of the crime?
Yes, I did.
And did you observe the body?
Yes, I observed this body firsthand.
Your Honor, I once again move to admit Exhibit 3 as the witness has testified to their personal knowledge and their personal experience viewing this exhibit and can testify to the authenticity of it.
At this time, I am going to allow it in.
Your Honor, permission for my co-counsel to publish Exhibit 3 to the jury?
Please do.
Ms. Cusack, what did you notice about the stab wound in Mr. Brackman's body?
As you can see in the photograph, the stab wound is horizontal.
And why was that important?
This is consistent with the intruder having had an altercation with the victim. Furthermore, the location and position of the knife indicates that the intruder was in close proximity with the victim, possibly constrained in a type of bear hug by the victim, and that the intruder then reached back and stabbed the victim in the upper back and shoulder area.
Now, I'd like to talk about how your conclusions in this case differ from that of the defense. What conclusions did they draw?
The investigator for the defense, Blake Van Owen, suggests that the intruder snuck up behind the victim and stabbed him in the back while he was seated at the kitchen table.
What's your opinion of that idea?
I disagree with it strongly. This would require the victim to have been surprised by the intruder.
Why do you think that that's an unlikely scenario?
First, the victim owned a ring security system, so he would have been alerted to the intruder's presence before they even entered the home. Secondly, the victim likely would have heard the intruder open the back door and walk across the kitchen floor. And third, for Van Owen's theory to be correct, the intruder would have been holding the knife in a backwards position, which is highly unusual. Not to mention the stab wound would have been vertical in nature. However, as we saw from Exhibit 3, the stab wound was horizontal.
What else does Van Owen's theory fail to consider?
Van Owen's theory doesn't explain the scuff marks on the floor, the broken plate, the open knife drawer, or the missing slot in the knife block.
And how do you know Blake Van Owen?
I've seen them at CSR conferences before. They were a police officer for a short time, but they were never a CSR. Van Owen simply reviews the work of actual CSRs, mostly by reviewing our reports and finding ways to reinterpret the evidence that we discuss.
How accurate is that process?
Reading a report will never provide a person with the same degree of understanding as physically being at the scene of a crime and directly examining the evidence.
Finally, I'd like to talk about what you concluded from this case. In your expert opinion, what conclusions do you draw about the circumstances of Mr. Brackman's death?
This was clearly a planned burglary gone wrong. The evidence shows that the victim was alerted to the intruder's presence by the ring security system and grabbed a knife to use for self-defense. When the intruder entered the home, a struggle ensued, and at some point, the intruder disarmed the victim, obtained the knife, and stabbed the victim.
Thank you, Your Honor. I have no further questions at this time.
All right, defense, cross-examination.
Yes, Your Honor.
Right,
May I have a brief time check before I begin?
Yes, you have 10 minutes and 1 second left.
Excellent, thank you. So, good morning, Ms. Kuzak. Let's just get right into it. First, I would like to talk about the knives which you found at the crime scene. You observed these yourself, correct?
Yes, I did.
Now, let the record reflect that the trial technician will display exhibits 6 and 8 on the screen for the purposes of showing them to the witness and opposing counsel. And you recognize these, correct?
Yes, I do. This is the murder weapon that was recovered from the victim's body.
And these are fair and accurate to what you observed, correct?
Yes, they are.
Thank you. At this time, the defense moves to enter exhibits 6 and 8 into evidence.
All right, prosecution, any response?
No objections, Your Honor.
All right, then they are so moved.
Now, Ms. Kuzak, referring to exhibit 6, this was the knife found near the victim's body, correct?
Yes, that's correct.
And this is a Chicago cutlery knife?
Yes, it is.
Now, moving to exhibit 8, that is a J.A. Heckles knife block, correct?
Yes, that's correct.
So you are confirming that these brands don't match?
Yes, the knife that we recovered from the victim's body did not match the others in the block. However, it is not uncommon for a person to replace a chef's knife if it has become damaged or lost.
But did you find any concrete evidence at the scene supporting this theory?
No, however, like I said, it's not uncommon for someone to replace a chef's knife, so it's normal that it did not match the others in the set.
Now, moving on, I would like to talk about the scuff marks. Let the record reflect that the trial technician will display Exhibit 18 on the screen, and it has already been entered into evidence. Now, you have no way of dating these scuff marks, correct?
Unfortunately, no, it is impossible to carbon date scuff marks.
And you have no before and after pictures of this floor?
No, I do not.
So you had no real factual evidence that these scuff marks came from the altercation on March 6th, correct?
Due to their location by the back door, which is where the intruder entered the home, I concluded that those marks were made during the struggle between the victim and the intruder.
However, they could have just as easily been made years before from moving in and out of the house.
I suppose that is possible, yes.
Now, moving on, during the investigation, images of blood splatters were lost, correct?
Unfortunately, yes, the files of the blood splatter were corrupted and are now unretrievable.
So the investigation you took part in lost evidence.
I do not know who is directly responsible for the corruption of those files, but that happened after I'd used them for my analysis, so I had no trouble using them in my investigation.
However, the jury cannot view these images today, isn't that true?
Unfortunately, that is correct, yes.
Thank you. Now, moving on, I would like to talk a little bit about the ring security footage. Now, you reviewed these videos in your investigation, correct?
Yes, I did.
And did these videos show any facial features of the perpetrator?
No, as you did see in the ring security videos, the perpetrator was wearing a Halloween mask.
And you had no way of linking that mask back to Avery Becker, correct?
No, I did not.
And you could not link the clothes the perpetrator was wearing to Avery Becker?
No, the only identifiable feature from that figure was height and build, which matched the height and build of the defendant.
But there was also no DNA from the perpetrator at the crime scene.
As you could see in that ring security footage, the perpetrator was wearing gloves, which is why there was no DNA found at the scene.
Thank you. And finally, I would like to move on to Exhibit 17. Let the record reflect that the trial technician will now screen share it. Now, you recognize this exhibit, correct?
Yes, I do. This is my witness tracking sheet that I created for my investigation.
Thank you. And do you make these regularly when you testify?
Yes, I do. This is part of my standard practice in investigating crimes.
And is it true that Exhibit 17 is fair and accurate to your work?
Yes, it is.
At this time, the defense moves to enter Exhibit 17 into evidence.
All right, any response from the prosecution?
No objections, Your Honor.
All right, then it is so moved.
Excellent, thank you. Now, if you would please refer to the annotations which the trial technician will make on this exhibit. If you would please look at the top right box under the column Perkins-Taylor. A portion of this text reads, provided statement re whereabouts with S1 on day preceding and day of homicide. Did I read that correctly?
Yes, you did.
So your report contains information that Taylor Perkins provided an alibi for Avery Becker on March 6th, correct?
Yes, that's correct.
Now, moving on to a second annotation, which the trial technician will create, a portion of the last line reads, unlocated party, Blair Rollins. Am I correct?
Yes, it does.
And so this is your own report, correct?
Yes.
And this acknowledges both the facts that Blair Rollins, an alternate suspect, was unlocated on the day of the crime, and that Avery Becker had an alibi?
I included Blair Rollins and that information in my witness tracking sheet as part of my initial investigation. However, throughout the course of the investigation, the evidence did not point to Blair Rollins as a suspect, which is why we concluded that Avery Becker committed this crime.
But you only did a comprehensive investigation into Avery Becker, is that correct?
Yes, because that is where the evidence led me to investigate her as opposed to other suspects.
But you never were able to locate Blair Rollins?
No.
And you consider an investigation in which one of your suspects remained unlocated comprehensive?
Again, the evidence did not lead me to Blair Rollins, so it was not necessary to investigate them further in the investigation.
Thank you, Your Honor. No further questions.
All right, prosecution, would you like to redirect?
Yeah, yes, briefly. Could I get a time check?
Yes, you have 1 minute and 41 seconds remaining.
Ms. Cusack, was your job to investigate suspects?
No, my role was to reconstruct the crime that took place on March 6th.
And did you do a thorough, comprehensive review into the reconstruction of this crime?
Yes, I did. I followed my standard practice and formula for reconstruction, and I provided all the evidence and information necessary to have an accurate analysis.
Thank you, Your Honor. I have no further questions.
All right, then. Prosecution, do you have any further witnesses to call at this point in time?
No, Your Honor. This time the prosecution rests.
All right, then the defense may begin their case in chief. So, defense, your first witness.
Yes, Your Honor. At this time, the defense calls Professor Blake Van Owen to the stand.
All right, you may proceed.
Yes, Your Honor. So, good morning, Professor. Can you please state your full name and spell your last for the record?
Good morning. My name is Blake Van Owen, Vanowen.
And could you please tell the jury a bit about your professional life?
I am a private investigator, a professor, and an expert witness in police practices.
And what is your experience with law enforcement?
I worked at the Aurora Police Department and then as a school resource officer, and then a private security guard, and then I went into private investigation.
And do you have any educational experience in police procedures?
Yes, I have a master's degree in criminal justice through Ashford University, and I taught a class on police procedures at the Community College of the Rockies and a class on police procedures and social justice at CU Denver.
Thank you. And have you ever testified in court before?
Absolutely. I regularly testify as an expert witness in many fields, such as police practices, use of force, false arrest, forensic evidence techniques, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
And which courts have accepted you as an expert?
I've been accepted as a defense expert in the U.S. District Court for the districts of Colorado, Kansas, and Arizona, and the state courts in Colorado, Wyoming, and Nebraska, and New Mexico.
Thank you. And do you have any other pertinent experience with court cases?
Yes, I have been accepted as an expert in crime scene reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times. I've consulted on over 100 cases.
Your Honor, at this time, the defense moves to enter Professor Blake Van Owen as an expert in police practices, cell tower analysis, and crime scene reconstruction.
All right, prosecution, do you have any response?
Yes, Your Honor. The prosecution would like to voir dire.
Yes, go ahead.
Professor Van Owen, you began your career in law enforcement as a police officer.
Yes, that is true.
After that, you worked as a school resource officer.
Yes.
Then as a security guard.
Yep.
But none of those occupations gave you direct expertise in crime scene reconstruction.
I've testified in crime scene reconstruction multiple times as an expert witness, and so I have decent expertise in the field.
Professor, that wasn't my question. My question was, none of those occupations gave you direct expertise in crime scene reconstruction.
I think being an officer of the police department in any facet gave me training in all sorts of things on crime scene reconstruction.
No direct expertise, Professor.
No.
Those occupations also gave you no direct expertise in cell tower analysis.
No, but also I have been accepted as an expert in cell tower analysis many times.
You now teach a class at CU Denver,
Yes.
and that class is on police practices and social justice.
Yes, I do.
So you don't teach about crime scene reconstruction,
No.
and you don't teach about cell tower analysis.
No, but I teach about police investigation tactics, which encompasses a lot.
Okay. And you have no formal training in crime scene reconstruction.
Not formally, but again, I have training as a police officer.
So no, not formally.
Not in crime scene reconstruction specifically, no.
You have no formal training in cell tower analysis.
Not specifically, no.
Your Honor, the prosecution does not object to the professor being qualified as an expert in the area of police practices. However, we do object on the grounds of Professor Van Owen being tendered as an expert in crime scene reconstruction and cell tower analysis, as we believe they do not meet the qualifications necessary to qualify them as an expert.
All right, she is so admitted in the field of police investigations. I will go ahead and admit her in the field of crime scene reconstruction because I find her argument that her prior work as a police officer is compelling. I will not allow her to be tendered in the field of cell tower analysis.
Yes, Your Honor. May I proceed with direct examination?
Yes, please.
Now, Professor, let's talk about the investigation which led to today's trial. What can you tell us about the quality of the police department's work?
After reviewing all of the police reports, the crime scene reconstruction, the cell tower reports, and the exhibits prepared by Detective Markowitz, and conducting my own partial investigation, I can tell you that the work the police department did was sloppy.
And what makes you believe this?
Kyle Cusack was obviously investigating with a suspect in mind.
And why do you believe that?
Cusack's investigation was blind to evidence that supported other, even more likely theories. Cusack even pulled pieces of narrative out of the blue with no evidence, such as the intruder stabbing Mr. Brackman with the same knife that he had retrieved from a knife block in the kitchen, just to make her story more coherent.
Now, allow me to direct you to what has been previously marked as Exhibit 20 and let the record reflect that the trial technician will display the exhibit. Do you recognize this?
Yes.
And what is Exhibit 20?
This is my official report analyzing the investigation done for today's case.
And how do you recognize this exhibit?
I made it myself.
And is this a fair and accurate copy of your work?
Yes.
And as an expert witness, do you regularly create reports such as this one?
Absolutely. It's part of what I do.
Your Honor, at this time, the defense moves to enter Exhibit 20 into evidence.
All right, prosecution, do you have any response?
Yes, Your Honor, we object as to hearsay.
All right, your response, defense.
Yes, Your Honor. Under Rule 803.6, this is an exception to hearsay. As Professor Van Owen has just testified, she regularly creates expert reports such as this one, and this is a record of a regularly conducted activity.
May I respond, Your Honor?
Yes, briefly.
If the professor would like to testify as to the contents of their report, they may. However, they have not testified as to how often they specifically create these records, and we do not believe sufficient foundation has been laid to prove that these are a regularly conducted business activity.
Response?
I'm actually going to go ahead and make a ruling. I'm going to allow you to get this information in, just you have to ask specific questions about it. I'm not going to admit the document wholesale.
Yes, Your Honor.
All right, you may proceed.
Now, Professor, if you could please refer to the second page of Exhibit 20, what do you believe is the most likely scenario of Mr. Brackman's death based on your investigation?
The most likely scenario was that Mr. Brackman was sitting, and the intruder behind him stabbed him, holding the knife as you can see in the picture. If Mr. Brackman were standing, the intruder would have had to be much bigger than him, which we can rule out from the ring video evidence.
Now, let's talk more about those ring videos you just mentioned. Can you please tell us more about them?
Yes. Even though Detective Markowitz makes a big deal about the ring alerts, I also have a ring security set up in my house, and I am aware of its pitfalls. A user can turn off push notifications, allowing an intruder to break in without the victim ever being aware. Markowitz did not collect records from Ring to check whether Brackman had his notifications on. And even if he did, he might not have had his phone on him at the time or have been paying attention and still would have been surprised by the intruder. Cusack just jumped to conclusions that the alerts were on.
Now, moving on, what can you tell us about how cell phones were investigated in this case?
Investigators used cell phone tower data to locate the phone, despite Avery Becker having been separated from her phone the entire day of the murder.
Now, if you could please refer to the 4th page of your report and let the record reflect that the trial technician will display that page on the screen. Did you review the functions of cell phone towers during your investigation?
Yes.
And what does this graphic on your report indicate about how cell phone towers function?
Cell tower data is much less accurate than GPS data.
This witness is not qualified as an expert in cell tower analysis and cannot testify as to how cell towers work, given as they have no expertise in the area.
Yes, I did make a ruling on that before, so I'd ask that you try and restrict the information about cell towers coming in.
Yes, Your Honor. Now, Professor, using the graphic included in your report, how far can cell phone towers reach?
They can reach up to 6 miles in each direction.
This report has not been admitted into evidence, and it's still outside the scope of the expertise.
Yes, I would once again request that you try to refrain asking questions about cell towers with respect to this.
Yes, Your Honor. Now, moving on, Professor, what can you tell us about how Detective Markowitz investigated information from cell towers in this investigation?
Detective Markowitz only subpoenaed the cell phone tower records for a limited window of time, so we only know that the phone communicated with the cell tower somewhere in the area. There is no way to tell that Becker's phone made it from her house to Mr. Brackman's house just before the murder.
And how else were phones considered in this case?
Well, since the prosecution only had one suspect in mind from the beginning, only cell data records from Avery Becker's phone were looked at. A smarter thing to do would have been to obtain cell records from all of the phones in the area and talk to anyone who had a connection with the witness or the victim. Especially important was Taylor Perkins' phone, considering that Becker was with Perkins the whole day.
And in terms of the screenshots collected by Detective Markowitz, what do you think of the quality of those as evidence?
The screenshots of the messages sent to the police by Alex Cifuentes were not questioned in the slightest. It is the job of the police to be skeptical. The Denver Police Department has the tools to run examinations on cell phones that could have verified or falsified this evidence, but they literally chose not to do the work.
And finally, what can you tell us about other possible suspects in this case?
Blair Rollins is a much more likely suspect than Avery Becker.
And are you familiar with the court case of Jonathan Rollins?
Yes.
And in preparation for testifying today, have you listened to what has been marked as Exhibit 22?
Yes, I have.
And as far as you are aware, has the prosecution also had this exhibit available to them?
Yes.
And are you aware of where this audio clip came from?
Yes, this was an audio portion from the trial of Jonathan Rollins, just after he was convicted to life in prison.
Thank you. And as far as the audio recording of the trial as a whole, was the clip in Exhibit 22 fair and accurate?
Yes.
At this time, the defense moves to enter Exhibit 22 into evidence.
Prosecution, your response?
Yes, we object to hearsay as well as lack of foundation.
All right, your response, defense.
Yes, Your Honor. This would be a recorded statement from a court, which would make it a recorded recollection. This came directly from the court case of Jonathan Rollins. And Professor Van Owen has also laid the foundation that that is where this came from and that she has reviewed that court case in preparation for testifying today.
May I respond, Your Honor?
Yes.
The professor has not testified as to how they know that this is an accurate representation or of how they obtained this recording in the first place. Therefore, we believe sufficient foundation has not been laid still.
Yeah. Would you be able to lay some foundation as to the authenticity of this recording?
Yes, Your Honor. Professor, was the trial of Jonathan Rollins a public matter?
Yes.
And are you aware of what Mr. Rollins said, or what came before what Mr. Rollins said in this recording?
Yes, Mr. Brackman failed to properly defend Jonathan Rollins as he was convicted to life in prison.
And so are you aware of what Jonathan Rollins was reacting to when he stated what is found in this audio recording?
Yes.
Could you please elaborate on that for the jury?
Yes. Obviously, anybody in this situation would be shocked and infuriated after, leaving your life up to a lawyer and having them fail. So Jonathan Rollins was very angry.
And are you aware of what Jonathan Rollins was convicted of and what his sentence was?
Yes, Jonathan Rollins was convicted of murder and sentenced to life in prison.
Your Honor, at this time, the defense moves to enter Exhibit 22 into evidence.
All right, I will allow it to be entered.
Yes, Your Honor. Let the record reflect that at this time, the trial technician will play the audio portion from Exhibit 22 for the jury.
I'll get you back, Brackman, if it's the last thing I do.
So, Professor, did this audio portion play a significant role in your investigation?
Yes. Blair Rollins' father was not only sent to prison, but he threatened the victim whose murder is being investigated today.
So, given your expert opinion and your own work on the investigation, how do you view the work done by the police department?
There were so many errors done on the prosecution's end. Not only did they investigate already considering Avery Becker guilty, they failed to obtain relevant cell tower records. They lost pictures of blood drops. The digital files were mysteriously corrupted. Any halfway decent police department would have kept more than one copy of digital photos from a murder investigation. I don't suspect malice. I understand it was incompetence.
Thank you, Your Honor. No further questions at this time.
All right, prosecution, would you like to cross-examine?
Yes, Your Honor.
All right, you may proceed.
Professor, I'd like to start by talking about your history of testifying in court. In your entire career, you've only ever testified for the defense?
That is true. The prosecution has the police department readily available to them for free. And so to make a living as a defense witness, I am available as a defense witness so that I can get paid and there are more jobs available to me.
So you rely on testifying for the defense to make a living?
Yes, it is my job, but I don't do it. Yes.
And you even like to think of yourself as a check on the power of the police?
Yes.
Now let's talk about your analysis of the crime. You never visited the scene?
No, I didn't.
You didn't do a full investigation into this case?
No, it's not my job to do a full investigation.
You assumed that Detective Markowitz influenced some of Ms. Cusack's findings?
Yes, well, the two were working on the same side of the
case.
You also assumed that Detective Markowitz is the one who planted the idea of Avery Becker as a suspect in Miss Cusack's mind.
Yes, I do. I think that the two of them together were just jumping to conclusions, and they failed to suspect anybody else other than Avery Becker.
But you had nothing to support that theory, did you?
Well, I have worked with Detective Markowitz and Kyle Cusack before, and I also know that Blair Rollins was a much more likely suspect, and Avery Becker was the only one investigated.
I'm sorry, that wasn't my question. You had nothing direct to support that conclusion.
Intuitively, it made a lot of sense, and it was pretty obvious.
No, that wasn't my question still. You had no direct evidence to support that.
No.
And isn't it your own belief, Professor, never to assume?
Yes.
All right. Moving on, let's talk about the evidence at the crime scene. It's your belief that the only evidence of a struggle was the scuff marks.
We can never know when the scuff marks happened, so we don't know if there was a struggle or not.
So that's a yes, you believe the only evidence was the scuff marks.
Yes, but I don't believe there was a struggle.
But there was also a broken plate and open knife drawer found at the scene, right?
Yes.
And you don't provide any explanation for either of those?
No, but there's a lot of evidence pointing to the fact that there was no struggle and that Mr. Brackman was sitting due to the ring video evidence and the way that...
Ms. Cusack, or Ms. Professor, I heard a no. You didn't address those?
No.
Isn't it one of your theories that Coach Brackman was murdered by someone who came to the house specifically to kill him?
Yes. Blair Rollins had a clear motive for murder.
But in the ring videos, as the assailant approaches the door, they're clearly not holding a knife, prepared to kill.
The knife could be hidden in a pant leg or a jacket. We don't know.
So that's a no. They weren't clearly holding the knife.
Not clearly, no.
You suggested that Blair Rollins, another student at CHS, could have killed Mr. Brackman.
Yes, absolutely.
And that was partially based off of the Jonathan Rollins court proceeding.
Yes, I believe it provides much more motive than a little high school mock trial drama.
But you don't know for sure that Blair Rollins was even in the room at the time that he made that statement?
Yes, he was.
How do you know
in the room?
That Blair Rollins was in the room?
In the trial with his father?
Yes.
Yes, Blair Rollins was there.
You weren't there personally, were you?
No, but it's a public court case, and so I am aware of what happened there.
But you don't know that Blair was in the room?
Blair was in the room. He was there to view his father being sent to prison.
But you weren't there, so you didn't observe that personally, did you?
Not personally, but it was a public court case, and so I'm aware of what happened there.
And you have nothing to prove that Blair was there during that time?
I don't personally, but I'm sure there is somebody else that can account for Blair's whereabouts on that day.
So you didn't choose to find anything to show the jury that Blair was there?
It's not my job to show the jury that Blair was there.
That was a no.
It's not my burden. It's the prosecution's burden to show where Blair was on the accounted day.
So that's a no. Finally, I'd like to talk about your compensation for being here today. You expect that your testimony here today will make you at least...
Objection, Your Honor.
Yes, on what grounds?
Under Rule 403, the discussion of Professor Van Owen's salary as to being here today is both unnecessary and could mislead the jury as to her intents.
Prosecution, your response.
This will not mislead the jury. I'm simply asking so that we can clarify the witness's potential bias, and it should be noted to the jury how much they're getting paid.
Yeah, I think that this is actually that this goes toward the credibility of the witness, and I think that that is relevant, and the jury should be made aware of that. So I'm going to allow this line of questioning.
Would you like me to repeat the question, Professor?
Yes, please.
You expect that your testimony here today will make you at least $1,000.
Yes.
And that's in addition to the just under $7,000 that you've already made by consulting on this case.
Yes, I get paid to do my work.
Thank you, Your Honor. I have no further questions.
All right, defense, would you like to redirect?
Briefly, Your Honor, and may I please have a time check before I do so?
Yes, you have 14 minutes and 5 seconds remaining.
Thank you.
All right, you may proceed.
Now, Professor, why do you only testify as a defense expert?
The prosecution has the police department free to them, and so they rarely use expert witnesses such as myself on their case. And so there's much more work available as a defense witness available to someone like me.
And as far as your own work, do you need to get paid for your job?
Yes, I do. Everybody does. We need to make a living so that I have food on my plate and a roof over my head.
Thank you. And finally, as far as the perpetrator bringing a knife into the home, do you believe they could have simply been holding the knife in a pocket?
Absolutely. The knife could have been anywhere on the person and just not shown in the ring videos.
Thank you, Your Honor. No further questions.
All right, then, Ms. Van Owen, you may return to your seat. And defense, would you like to call your next witness?
Yes, Your Honor, the defense calls Ms. Taylor Perkins to the stand.
All right, you may proceed.
Good morning, Ms. Perkins. Could you please state your name and spell your last for the record?
Sure thing. Taylor Perkins, Perkins.
Now, Ms. Perkins, tell us a bit about yourself.
Sure. I'm a freshman at CU Boulder this year, which is very exciting. I graduated from Colorado High School last year, which I was in a plethora of clubs, including mock trial.
Did you have any friends in mock trial?
Yes, my very best friend Avery Becker was on the team with me, which was a lot of fun.
And who is Avery Becker?
Avery was my best friend, definitely the best lawyer on mock trial, no doubt about that. Avery had to put in very little effort to succeed in mock trial. She was just naturally talented. That definitely bugged some people on the team, including our coach, but Avery's passion for the team definitely made up for it.
Could you tell us more about this coach?
Yeah, Coach Brockman, he was a great guy, and quite honestly, it's sad to think that he's not with us anymore. Him and Avery didn't always get along. He quite honestly just wanted the best for Avery, and so they had somewhat of a feud sometimes, which in my opinion was just kind of childish and foolish.
Can you tell us more about this feud?
Yeah, right before regionals last year, Avery came kind of unprepared and wasn't really ready for the regional tournament, which caused Coach Brockman to kick her down to the B team.
And what did you do in light of this event?
I stepped down in honor of Avery. I felt like that was the right decision.
And was this a big sacrifice for you?
No, Avery was my best friend and the best lawyer, as I said. And Avery deserved that spot after some hard work. And quite honestly, it paid off because Avery got best attorney and best closing argument at regionals.
Now, were there other examples of this feud?
Yes, Avery took what she believed to be a dry erase marker and wrote Worst Attorney Award on Coach Brockman's car, which ended up being a permanent marker and made Coach Brockman upset, kicking Avery off the team.
And what happened after that?
I thought it was unfair that Avery was kicked off the team. It was an honest mistake. And after that, state got canceled due to COVID and we all kind of moved on.
And backtracking to Avery's attempts to get back on the team, how did that play out?
Avery texted all the team members on the team, including Alex Cifuentes, which was kind of bizarre to me because they weren't really friends. And with that not working, Avery went and tried to appeal to Coach Brockman at practice, which still didn't work. And so in order to blow off some steam, me and Avery went and hung out at the mall and went to the Fry Shack. And after seeing some team members, Avery had lost her phone.
And you say that Avery lost her phone. What did you guys do about that?
Yeah, so the next day we skipped school and went and tried to retrace Avery's steps, looking at the mall and calling her phone. And with no luck, we went back to the Fry Shack, which was one of the last places that the phone may have been.
And did you see anyone that you knew at the Fry Shack?
Yeah, we did. It was kind of bizarre. We saw some team members there, and they said that Coach Bachman never showed, which I guess now we know why.
And then was anyone else gone from school that same day?
To my knowledge, a kid named Blair Rollins, who was kind of a weird.
Personal knowledge.
All right, defense to your response.
I believe I've laid the foundation that Miss Perkins has been at school, would be aware of her classmates' whereabouts, and her classmates, wherever like they were at, like she would be in contact with them.
Your Honor, may I respond to that?
Briefly.
Your Honor, as Ms. Perkins has already testified, she was not in school at the day of the murder and therefore cannot testify as to where Blair Rollins was on the day of the murder.
Yeah, I'm gonna go ahead and sustain that objection. So just move on.
Okay, and finally, in light of the incident with Mr. Brackman's car, why did you remain friends with Avery?
Avery tried to apologize multiple times and told me it was an honest mistake. And although Avery committed vandalism, Avery's not capable of murder.
Thank you, Your Honor. No further questions.
All right, prosecution, would you like to cross-examine?
Yes, Your Honor.
All right, you may proceed.
Ms. Perkins, I'd like to start with your relationship with Avery Becker. Avery Becker was your best friend?
Correct.
And the only reason you joined the team was because your friend did?
It was more of a social aspect for me than it was other kids.
You and Avery thought that Brackman was a mediocre coach, yes?
At times, yes.
You described Avery's behavior as rash?
At times, she could be rash, correct.
And you thought that she had an inflated ego?
Sometimes she was good and knew it.
But you were still good friends despite this?
That's correct.
So much so that a week before the mock trial regionals, you quit the team in support of Avery.
Avery was my best friend, and that was the right decision.
So that's a yes, you did quit the team.
Yes, I would want Avery to do that for me if I was in that position.
Let's talk about what you did once Avery was removed from the team. Are you aware that Avery was really upset and distraught after being removed from the team?
As I would have been, yes.
But you weren't at the practice where Avery vandalized Mr. Brackman's car.
That is correct.
You talked to Avery after this practice?
I talk to Avery all the time, correct.
You talked to Avery specifically after the practice, yes?
Correct.
But you didn't see any of what Avery said or did while in that emotional state.
That is correct.
Now, you're aware that Avery has denied ever texting Alex Cifuentes for help getting back on the team?
That Avery denied?
Yes.
That is correct.
But you said in your statement that Avery did text everyone on the team, even Alex Cifuentes.
Avery and Alex weren't friends, so they didn't text often, but Avery did text saying that she wanted to get back on the team.
So that was a yes.
In my statement, yes.
After Avery was removed from the team, you went to the Fry Shack?
We went to the mall and then the Fry Shack.
Where you then claim Avery lost her phone?
That is correct.
But you also say that their phone was like a third kidney and it was never out of reach.
As most teenagers, correct.
So your story is that your best friend, who you texted with all the time and played games with you on her phone, didn't notice that her phone was missing until a day later.
Avery was not having a good night. That's probably true. Her mind was on other things. That's correct.
I heard a yes.
Correct.
And you were the one who pointed out that the phone was missing, not Avery.
I'm not sure if Avery noticed earlier, but I pointed it out to Avery and we both realized.
So we only have your word and the word of your best friend that the phone was lost at all.
That is correct, but I'm not quite sure why Avery would lie and make me waste a day of school to go and look for her phone, being that she knew school is important to me.
I'm sorry, Ms. Perkins, that wasn't my question. I was simply asking if we only have your word and the word of your best friend that this phone was indeed lost.
Yes, that is correct.
I'd like to talk about your whereabouts on the day of the murder. You say you and Avery were together for the entire day looking for Avery's phone,
That is correct.
but you have no one who can support your story other than Avery?
I'm sure that if you looked at the mall cameras that me and Avery would be seen.
But we don't have that evidence here today, do we?
Unfortunately, no, the prosecution didn't bring that evidence.
And you had technology available to you, like Find My Phone, that you could have used to find this missing phone?
Unfortunately, I tried and called Avery's phone, but I have an Android, which I don't have the feature of Find My iPhone
So you didn't use this technology?
because I don't have access to it. Correct.
And you and Avery discussed the murder of Mr. Brackman after the news broke?
That is correct. I was very sad, and as Avery was, I'm sure everyone in the community was devastated.
And this was before Avery's lawyers contacted you about being a witness?
That is correct.
I'd like to talk about the defense's notion that Blair Rollins was somehow involved in this case. You claim that Blair Rollins, another student, might have committed the murder?
That is correct.
But you have no evidence or witnesses to support this theory.
As being a high schooler, I come up with ideas in my head, and that's correct. I have no evidence proving so, but that's my theory.
So, no evidence or witnesses, yes?
That's correct. I'm not a lawyer.
And the defendant, Avery Becker, was the one who suggested this theory to you.
I came up with that in my head in the first place, but Avery did point it out, and we both agreed.
So Avery did influence this theory?
Not necessarily.
Calls for speculation.
Yeah, I'm actually going to go ahead and sustain that objection.
I'll move on, Your Honor. You say that Alex Cifuentes was good friends with Blair Rollins?
They were friends to my knowledge, correct? Yeah.
And lastly, when Avery was in trouble before, you quit the team in order to help Avery.
That is correct.
And now you're the only person who claims to have seen Avery during the time of the murder.
Avery's my best friend, and when she was in a difficult situation, I helped her out, but Avery's not capable of murder.
I was simply asking if you are the only person here who claims to have seen Avery during the time of the murder.
That is correct.
Thank you, Your Honor. I have no further questions.
All right, defense, would you like to redirect at this time?
Yes, Your Honor, briefly.
All right, you may proceed.
Thank you. Ms. Perkins, what were you two doing the day of the murder?
We were looking for Avery's phone at the mall and at the Fry Shack.
And why wasn't she answering her texts the morning of the murder?
Avery didn't have her phone, and it was just a regular routine that she would pick me up, so we didn't necessarily need to clarify that she had texted me.
And why was she not, why did it take a day for her to realize that she had lost her phone?
Avery had worked really hard to be on mock trial and be on varsity her senior year. So when she was kicked off the team, Avery was really upset and in a state of upsetness and sad.
And finally, was it a sacrifice for you to drop down to the B team?
Objection asked and answered.
No.
All right, I'm going to allow that question in.
I will repeat the question. Was it a sacrifice for you to drop down to the B team?
No, Avery was my best friend, and she was good at mock trial and deserved to be there. I was really only there for her, and quite honestly, it was the right decision. I would want a friend to do that for me.
Thank you, Your Honor. No further questions.
All right. Defense, at this time, would you like to call any further witnesses?
The defense calls Avery Becker to the stand.
All right, you may proceed.
Please state your name and spell your last for the record.
My name is Avery Becker, spelled Becker.
Ms. Becker, why are you in court today?
I'm today here in court because I am wrongly accused of murdering my former coach, Mackenzie Brockman.
Could you be a little bit more specific about who Mackenzie Brockman was to you?
Of course, Mackenzie Brockman was my mock trial coach for the 4 years that I was a part of the program at Colorado High School, or CHS.
Now, let's walk through your relationship with Mackenzie Brockman. What was your relationship like with Mr. Brackman?
Although I did respect his ability to get the team to a competitive level, Mr. Brockman and I did have our disagreements and did not see eye to eye.
And how did Mr. Brackman criticize your work ethic?
He criticized my work ethic with hurtful and humiliating comments, and also by demoting me from the A team to the B team at one point.
Can you describe this demotion in a little bit more detail?
Yes, so I came to practice one day just like any other. And as soon as I got there, I guess I might have seemed unprepared or something along those lines. And Mr. Brockman became quite angry with me and demoted me from the A team to the B team.
And I understand that you made it back onto the A team. How did you make it back onto the A team following this incident?
Well, my best friend Taylor Perkins, who you just heard from, took it upon herself to step down from the A team on mock trial. And as a result of that, I was reinstated on the A team.
And did you go to the regional tournament after this?
Yes, I did. And in fact, I won Best Attorney and Best Closer at the regional tournament.
How did Mr. Brackman react to these accomplishments?
Well, I had expected praise and perhaps even just a compliment. However, at the next practice, Mr. Brockman criticized my work and told me that I was not deserving of either of these awards.
And how did you react to these comments by Mr. Brackman?
I was quite upset by these comments, especially since they were said in front of my entire team.
What happened next?
Well, I did one of the stupidest things I've ever done in my entire life. I walked out of practice holding what I thought was a erasable marker and wrote across the hood of Mr. Brockman's Porsche Worst Attorney Award.
How did Mr. Brackman react when he saw this?
Well, understandably, he was very angry with me and immediately kicked me off the mock trial team.
How did you feel after this incident?
Well, I was upset, but I do agree that I did deserve to be kicked off the mock trial team. However, I did try and make amends, and I attempted to apologize to Mr. Brockman in person at his office, through text message, and even by asking my former mock trial teammates to apologize on my behalf.
Now, moving on to March 6th, the day of Mackenzie Brackman's death. Where were you on March 6th, 2020?
I was with my best friend Taylor Perkins, and we were searching for my phone the entire day.
What had happened to your phone?
Well, at some point the day before, so March 5th, I had lost my phone.
And where did you last see your phone?
The last time I can vividly remember seeing my phone is at a table at the Fry Shack just after Alex Cifuentes had played a game on that phone.
Now, just to clarify, you were not at Mr. Brackman's house on March 6th?
Absolutely not. There is no way I could have possibly been at his house, seeing as I did not know his address until this case came to court.
Now, Ms. Becker, you heard today that Alex Cifuentes claims that you sent text messages to her?
Yes, I did hear that.
Let the record reflect that the trial technician is screen sharing what has previously been marked as Exhibit 14. Ms. Becker, have you ever seen the text messages depicted in these screenshots right here?
No, I have never seen these text messages before.
And Ms. Becker, you heard that Alex claims to be your best friend?
Yes, I did hear her claim that. However, that is very untrue. I interacted with Alex as little as possible, and the only time I ever really saw her was in the team setting at mock trial.
What was your relationship like with Ms. Cifuentes on the team?
Well, I would definitely say that we were competitors, and I might even go so far as to say she was potentially jealous of me, seeing as I got...
Speculation. This witness cannot testify to the state of mind of Alex Cifuentes.
All right, defense, your response.
Your Honor, this is simply Ms. Becker's observations of how Alex felt towards her as they were on the same team, and she observed this.
Your Honor, permission to respond?
Yes.
The Ms. Becker stated that she believed that Alex Fuentes was jealous of her, but she has no way of knowing the witness's state of mind, regardless of how long they spent on the mock trial team together. She cannot testify to Alex Fuentes' state of mind.
All right, I do agree with the objection, so I'm going to go ahead and sustain that.
Yes, Your Honor. I'll move on. Ms. Becker, you claim that you're not friends with Alex Fuentes. So if you're not friends with Alex Fuentes, then who is?
Based on my observations of who Alex Fuentes hung out with at school, I would say Blair Rollins.
Objection, speculation. This witness does not have enough personal knowledge to say who Alex Fuentes was and was not friends with.
Response, Your Honor?
Yes, please.
Your Honor, I believe the Avery Becker would be able to testify to this as she went to school with these two classmates and therefore saw them in the hallways or in classes together.
Yeah, and I believe that Ms. Becker stated it was based on what she had observed at school. So I will allow this in as her rationally based perceptions. So I'm going to overrule the objection.
Ms. Becker, I'll repeat my question. If you're not friends with Alex Fuentes, then who is?
Well, based on my observations of Alex at school, she did hang out with Blair Rollins.
And Ms. Becker, do you know Blair Rollins?
Not personally, but I do know of Blair Rollins.
And what is Blair Rollins' connection with Mr. Brackman?
Well, Blair Rollins' father was recently sentenced to life in prison for murder, and this followed his poorly executed defense by Mackenzie Brockman.
Ms. Becker, how would you describe Blair Rollins physically?
Blair Rollins is the same height and build as myself, and we were often mistaken for each other at school.
Where is Blair Rollins?
To my knowledge, nobody knows where Blair Rollins is.
Lack of personal knowledge.
All right, defense, do you have a response to that?
Your Honor, I believe the witness can testify to this as she has not seen Blair Rollins at school after this incident.
All right, I am just going to limit that to Ms. Becker. Sounds like you do not personally know where Blair Rollins is.
No, I do not.
All right, so I will allow that in. But as for whether or not anyone knows, I don't know if Blair can testify to that. I don't believe she can.
And lastly, Ms. Becker, did you kill Mr. Brackman?
Absolutely not. I did not kill my former coach, Mackenzie Brockman.
Thank you, Your Honor. No further questions.
All right, defense, would you like to cross-examine?
Yes, Your Honor.
All right, you may proceed.
Good morning, Ms. Becker.
Good morning.
I'd like to begin by talking about your time on the mock trial team, including your relationship with Coach Brackman. You had been on the mock trial team for 4 years?
Yes, I was.
And at practice, you would often text Taylor Perkins and play games with each other?
Yes, we joined mock trial as a way to hang out more with each other.
And Brackman often got mad at you two because of this?
Yes, he did.
But you believed that Brackman was just hard on you because he was jealous of your abilities as an attorney.
That is my belief. I was naturally gifted in mock trials, so I didn't have to work as hard as others.
So that's a yes.
Yes.
And you two argued frequently during practice?
Yes, we did.
I'd like to move on to talk about why you were kicked off the mock trial team. About a month before the regional tournament, Brackman got mad because you came to practice what he believed was unprepared again.
Yes, that is the reason he gave me for demoting me from the A team to the B team.
That's right, he did demote you to the B team, correct?
Yes, as I just stated.
And you got your friend Taylor to quit so that he would put you back on the A team.
Actually, no, that was Taylor's idea, and Taylor took it upon herself to step down from the A team, and as a result, I was reinstated.
But Taylor did quit.
Yes, Taylor did step down from the A team.
And because of that, you were able to be on the A team for regionals.
Yes, I was.
And after regionals, when Coach Brackman attempted to give you some feedback on your performance, you refused to listen.
I would not call that feedback. In fact, I would call it criticism, what he tried to say to me.
But you did storm out of practice, correct?
Yes, the comments he made were very hurtful and humiliating.
And they made you angry.
They did make me upset.
Objection, Your Honor.
Yes, what was the objection?
Your Honor, I anticipate that the prosecution is trying to establish that the witness acted in conformity with this trait of anger, but under Rule 404A1, unfair character evidence, the evidence of Avery Becker's anger is not admissible to prove that on particular occasions she acted in accordance with this trait.
Your Honor, under Rule 404B2, evidence may be admissible for other purposes, such as motive. In this case, I will go on to use this incident to show the motive that Avery Becker had due to the animosity between her and her coach. This is not being offered to prove that Avery committed murder in conformity with the character of someone who vandalized a car, but rather simply being offered to show motive, which is admissible under Rule 404B2.
I'm inclined to agree with the prosecution here, so I'm going to overrule the objection and allow this question.
Would you like me to ask the question again, Ms. Becker?
Yes, please.
You were angry with Coach Brackman, correct?
I was upset with Mr. Brockman, yes.
And so you took a permanent marker, a Sharpie, and wrote the words "Worst Attorney Award" on the hood of Coach Brackman's Porsche.
I would like to clarify that at the time, I did think it was a dry erase marker, but to answer your question, yes, that did occur.
So he kicked you off the team for good?
Yes, and I totally deserved that course of action.
And that devastated you?
I mean, I was upset at the time, but looking back on it now, I understand that I did deserve that.
I'd like to move on to talk about your whereabouts on the day that Coach Brackman was murdered. The last place you claim to have seen your phone was at the Fry Shack the day before the murder, correct?
Yes, it was in the hands of Alex Cifuentes.
So your story is that after the Fry Shack, you never once tried to use your phone to play games?
I was walking around the mall with my best friend Taylor Perkins, and we were talking, so I had no need for my phone. Then I went home and went straight to bed, so once again, I had no need for my phone. It wasn't until the next morning when Taylor tried to text me that I realized that my phone was missing.
So that's a no. You never once tried to use your phone from the time that it was missing until the morning of March 6th when you realized it was gone?
No, I never tried to use my phone.
And you claim that Alex Cifuentes probably took your phone.
That is my belief, seeing as the last place I can vividly remember my phone is in the hands of Alex Cifuentes.
But you have brought no proof or witnesses today that Alex stole your phone.
Considering I'm a college student, I would not consider that my job to do.
But nobody today is testifying that Alex stole your phone?
Taylor Perkins, my best friend, can testify to that fact as well.
But you guys don't have any proof of this?
No concrete proof, no.
And you also claim that you were with Taylor Perkins on March 6th?
Yes, we were together the entire day.
And you were in public places like the mall and the Fry Shack?
Yes, we were.
But there is no one else here to corroborate your claims except your best friend, Taylor Perkins?
Well, I'm sure there are video cameras and employees at these different locations who can vouch for my whereabouts, but no, they are not here in court today.
Thank you. You have also claimed that Alex was possibly conspiring with Blair Rollins to set you up.
That is my belief, yes.
But again, you have no proof of this alleged conspiracy.
Once again, I am innocent until proven guilty, so I did not feel the need to provide this evidence.
So that's a no.
No, I did not provide this evidence.
Finally, you claim that you never sent the texts that Alex presented earlier today.
I did not send those text messages. That is correct.
But you did tell your mother that you would get back at Brackman even if it was the last thing you did.
I did say those words in a moment of passion.
Thank you, Your Honor. I have no further questions.
All right. Would defense like to redirect?
Yes, Your Honor, but before I do that, can I get a brief time check?
Yes, you have 2 minutes and 6 seconds left.
Thank you. Now, Ms. Becker, why did you argue with Mr. Brackman at practices?
Well, Mr. Brockman would call me unprepared and undeserving of some of the awards that I won, and that was very frustrating to me, so I did defend myself.
And Ms. Becker, is it justifiable to be upset when somebody criticizes you?
I do believe so.
Now, Ms. Becker, who is in contact with your phone at the Fry Shack?
As I said before, the person that I can vividly remember holding my phone, and also the last time I saw my phone, was in the hands of Alex Cifuentes.
And what were you doing that made you not realize that your phone was missing?
Well, I was with my best friend Taylor Perkins at the mall for the time after we were at the Fry Shack. So we were talking and shopping, so I had no need for my phone. Then I got home and ate dinner and went straight to bed. So once again, I did not need my phone. And it wasn't until the next morning that I realized it was missing.
And Ms. Becker, is it your job to find witnesses about your whereabouts for today's trial?
No, I do not believe it is my job. Seeing as I'm innocent until proven guilty, this is the burden of the prosecution.
And finally, Ms. Becker, what were your emotions when you said you would get back at Mr. Brackman?
I was upset about just being kicked off the mock trial team, and I meant that I was going to prove to Mr. Brockman that he needed me to go to state, and that was getting back at him, as I said it, was just demonstrating that he did need me.
Thank you, Your Honor. No further questions.
All right, Ms. Becker, you may take a seat. And defense, do you have any further witnesses you would like to call?
The defense rests its case.
All right, then at this point, we will go ahead with closing statements, beginning with the prosecution.
Yes, Your Honor. And for clarification purposes, can you all see and hear me okay?
Yes.
I would also like to remind the court that the prosecution has asked to reserve any remaining time for rebuttal.
Acknowledged.
Thank you. Are the timekeepers ready?
I'm ready.
Okay.
I'm ready as well.
Ladies and gentlemen of the jury, today you have heard the story of a disgruntled teenager with a history of violent outbursts when they did not get their way. On March 6th, 2020, Avery Becker, mad at their mock trial coach for kicking them off the team, traveled to their coach's home and broke in, committing second-degree burglary and then first-degree felony murder when their coach died in the course of this break-in. Avery Becker's tragic arrogance and tragic choices led to a tragic consequence: the death of their coach, Mackenzie Brackman. Now, in order to prove that Avery Becker committed second-degree burglary, we must have proven that they entered unlawfully into a dwelling with the intent to commit criminal mischief against another person or property. Today, we have done just that. To show that Avery Becker broke into Mackenzie Brackman's home, we presented expert testimony of Jordan Markowitz. Detective Markowitz showed you Exhibit 16, depicting the exact course that Avery Becker took to get from her home to Mackenzie Brackman's home on March 6th, triangulated through expert analysis of cell phone records from that day. You also saw Exhibit 12, video footage of someone matching Avery Becker's exact height and build breaking in to Mackenzie Brackman's home. You also heard testimony of Alex Cifuentes, a former teammate of Avery Becker, who testified to the long-time animosity between Avery Becker and her coach, Mackenzie Brackman. Alex also told you about Avery's history of vandalizing her coach's car when she was simply frustrated with him one day after practice. Finally, you saw text evidence of a conversation between Alex Cifuentes and the defendant, Avery Becker, in which the defendant stated her intent to travel to her coach's home, break in, and trash it. Now, in order to prove that Avery Becker committed first-degree murder, we must have proven that 1, she committed or attempted to commit second-degree burglary, and 2, in the course of this break-in, the death of a person was caused by anyone. Today, through expert testimony of Kyle Cusack, you heard this story of a break-in gone wrong. Avery Becker, mad at their mock trial coach, traveled to their coach's home, and when they were interrupted by Mackenzie Brackman, a struggle ensued between the two. And Avery Becker grabbed a knife from her coach's home and stabbed Mackenzie Brackman in the back, murdering him. Now, the defense has tried to distract you today with wild theories about Blair Rollins and some far-fetched idea about manufactured texts. Yet all of these theories are vague and speculative. Instead, you have heard us, the prosecution, present ample evidence to prove beyond a reasonable doubt that Avery Becker committed second-degree burglary and first-degree murder on March 6th, 2020. The events that occurred on March 6th were a tragedy, but Avery Becker must accept the tragic consequences of their tragic choice. So we, the prosecution, ask that you find the defendant guilty of all charges. Thank you.
Defense, your closing statement.
Yes, Your Honor. Your Honor, members of the jury and opposing counsel. My name is Raina Hilden, and today, along with my co-counsel, Cindy Nguyen and Maggie Holland, we have had the honor of representing the defendant of today's case, Avery Becker. At the beginning of this trial, my co-counsel, Cindy Nguyen, reminded you that the prosecution carries the burden of proof, meaning that they had to prove to you beyond a reasonable doubt that Avery Becker is guilty. However, members of the jury, in this case, we have found not only reasonable, but substantial doubt as to the prosecution's argument, because they jumped to conclusions and ultimately fell short. First, the prosecution's witnesses came to the stand. Detective Markowitz and Kyle Cusack both testified to their findings, but their information was based on nothing but speculation. The prosecution has claimed that Avery Becker was the one who was a victim of tragic arrogance. However, that title of arrogance belongs only to the investigators of this case. Detective Markowitz did not find it necessary to verify text screenshots brought forward in order to supposedly indicate an intent, simply assuming that they were true. And Kyle Cusack made baseless conclusions in her reconstruction work. Alex Cifuentes, additionally, admitted to you today, members of the jury, that having Avery Becker off of the mock trial team would benefit her and give her a larger role on the team, adding only bias against Miss Becker. Then the defense witnesses came to the stand. Professor Blake Van Owen, an expert with extensive experience, provided to you, the jury, an analysis of all of the flaws in the prosecution's case and highlighted how they completely overlooked a suspect with a much greater motive, Blair Rollins. Next, Taylor Perkins provided an alibi as to the location of Avery Becker the day preceding and day of the murder. This alibi provides the location of Avery Becker the day of the crime, as well as, and Ms. Perkins also provided a better understanding to the jury about how Avery Becker attempted to make up with Mr. Brackman after making mistakes. Then Avery Becker came to the stand. She wanted, after being kicked off of the mock trial team, to prove herself to Mr. Brackman that she could perform well again and continue to finish off her mock trial senior year on a good note. Next, let's talk about the evidence. First, let's talk about what we don't have in this investigation. We do not have an accurate method of placing Avery Becker's cell phone. We do not have all of the evidence, the prosecution having lost photographs during the investigation. And we do not have verification on the screenshots with which they believe indicate a motive. And finally, we do not have any identifiable perpetrators or any identifiable features of the perpetrator shown in the ring security videos. Next, let's talk about what we do have. We have an alibi for Avery Becker provided by Taylor Perkins. We have evidence that Avery Becker lost her cell phone the day preceding the murder, indicating that the location of the cell phone and Miss Becker would not even correlate with one another. And finally, we have a suspect with a much greater motive who the prosecution failed to investigate in Blair Rollins. Professor Van Owen showed for you today an audio portion from the trial of Blair Rollins' father, in which, after being convicted, Mr. Rollins threatened the victim whose murder is being discussed today. So ultimately, members of the jury, we do have reasonable doubt in this case. Avery Becker is being wrongly accused of murder, and we very clearly see this in the reasonable doubt found today because the prosecution jumped to conclusions and fell short. The prosecution has claimed that tragic consequences came about from Avery Becker's actions, but Mr. Brackman's death was not caused by Avery Becker. Yet another tragic consequence could come from your ruling today, members of the jury, Avery Becker's life being ruined over a crime she did not commit. And for the reasonable doubt that we have seen throughout this entire case, we ask that you find Avery Becker not guilty. Thank you.
All right, prosecution, your rebuttal.
Yes, and can I get a brief time check?
Of course, you have 1 minute and 11 seconds left.
Now, the defense has tried to sow seeds of doubt, saying that our case jumps to the easiest conclusions, falling short of our burden of proof. But you have heard the concrete evidence today. Who matched the height and build of the video footage from the scene? Avery Becker. Whose phone records showed them traveling to their coach's house on the day of the murder? Avery Becker. Who sent texts stating their intent to break in and trash their coach's home? Avery Becker. Who had a long-time animosity with Mackenzie Brackman? Avery Becker. Who stated that she would get back at Brackman if it was the last thing she did? Avery Becker. When you look at all of this evidence, it no longer becomes the easiest solution, but the only logical one, leaving no room for reasonable doubt.
Will be sent to the jury for scoring. So I'll be giving our panelists a little bit to score. In the meantime, I will give everyone some feedback. So if you could turn on your cameras. So I think everyone here did a really fantastic job. You guys are in the 4th round of the state tournament. You're probably all completely exhausted because this has been going on for 2 days, 3 days, something like that. I've been here through this whole time too. So it's great that you're still putting out the effort this far in, and I think a lot of it really showed. Guys did great with your openings and closings. I really liked what I saw on cross. Good witness control, great job of pinning the witness into a corner to get the answer that you want. I think that's really what you want to do in cross-examination. So with that, I'm going to open it up to the panelists to give some feedback as well.
I thought everyone did an absolutely fantastic job. I was especially impressed by all of the crosses. It's not an over-exaggeration to say I regularly run into opposing counsel that is less competent and well less prepared than all of you. So I know you all put in a great deal of time into this, and I appreciate it. I especially like the openings and closings in this one. Really, tracked chronologically, told a good story throughout the entire thing. It came across, a couple of directs that maybe didn't lay things out in a chronological order that was easy to comprehend, and I thought everyone did a great job of that. So, good job. Congrats, everyone. Well done.
Yeah, I think everybody did really, really good. I especially liked your guys' use of objections. And just on top of that, I thought you guys handled them really well. You didn't let, having something overruled or be sustained throw you off your game. You just kind of rolled with it, and you guys did a really good job overall.
Do we have any other panelists?
Judge Cohen, I can't start my video. I'm Sarah Toohey.
All right, that's fine.
What I would say is similar to what they told us in law school, that that our performances were terrific and good in the real world. And I think you should know that you did everything very, very well. And when you go see trials, you're going to be surprised at how well you did today.
All right, monitor, do we have all the scores in?
We do not yet. Nick, I'm still waiting on yours. Did you hit submit?
Yeah.
Huh.
I just have a loading screen. Oh, it changed. Well, no, it's still twirling.
Okay. Let me keep you here until it comes in. There it is. We're good.
All right, so that's everyone.
That is it. I just want to thank the teams. You guys are amazing for pivoting and doing it in this crazy format. And especially thank you to the volunteers, because we couldn't do any of this without you guys. We really, really appreciate it. So everybody, be safe in Snowmageddon. It's actually finally starting to snow. And thank you again. Have a good weekend.
Thank you, Your Honor.
Thank you so much. Thank you, everyone. Your Honor.
Thank you.
Thanks, Ryan.